Imagine this. You're in school and every single classroom has a camera. जहाँ रिसेस हो रहा है वहाँ कैमरा है, जहाँ कॉरिडोर्स है वहाँ कैमरा है, ग्राउंड में भी कैमरा है. Any other place except the washroom has cameras. And this camera का live feed is directly going to your parents. And your parents are able to have a 24 hours vigil on you, be it at home or school. How much freedom do you think you'll have? पेरेंट्स को हो सकता है ना पसंद आए तुम किसके साथ टिफिन शेयर कर रहे हो या तुम अगर क्लास में बातें कर रहे हो या कुछ कर रहे हो. पेरेंट्स विल बी एबल टू सी दैट. And at the same time, when your exams are coming, your invigilator is walking beside you. You have your parents watching you through the camera and invigilating your exam itself. जिससे तुम घर आओगे and तुमको जवाब देना पड़ेगा how the exam actually was and why were you looking here and there. How much freedom do you think you'll have? Will you be able to do even 50% of the things we did in school? Now zoom this out a little bit. अब ये scenario assume करो, same चीज़, but now in your public life. Wherever you're going, wherever you're walking, whoever you're meeting, whoever you're talking to, or whatever you're eating is being monitored. And this monitoring is now मम्मी पापा के पास नहीं जा रहा है. It's now going to the government. The government is now able to monitor you and surveil you. Similar curbs on your freedom, but now you're not in school. This is your public life. And now zoom out a little more. जहाँ पे our life is not just our physical interactions with people or our physical world where we're eating and talking, but it is also a digital life where we are talking to people online, where we are reading things online, हम लोगों से बात कर रहे हैं, पढ़ रहे हैं, interact कर रहे हैं, we are buying things online. And now these people who are behind these websites are collecting this data and creating a profile out of you. They are creating a profile which says this is a 24, 25, 26-year-old person who's fairly unemployed, is preparing for government exam, has interest in buying certain things, is playing games or visiting certain websites. And based on this, they're selling this data to different companies and giving it to the government. In that case, the government is looking at you and these different companies are targeting ads at you. वो तुमको वही चीज़ दिखा रहे हैं जो तुम buy करोगे, जो तुम खरीदोगे. So they are taking away that autonomy and choice that you might even want to buy something else. And the government is profiling you. Government is looking at, okay, I've seen this person's internet activity. I don't deem fit that this person is going to be a good match in our government jobs. This person might not be deserving of a better insurance. This person might not be deserving of a better loan, right? And this is the reason why we need to talk about right to privacy. अब राइट टू प्राइवेसी का जो क्वेश्चन है, और बाय द वे ये जो तीनों सिनारियोज हमने अभी पेंट किए हैं, these three scenarios are very much real. The Delhi government has already spoken about installing CCTV cameras all over the classrooms in Delhi government schools. जिनका live feed will go to parents and they call this a way of inculcating discipline. The privacy issue never comes in questions like these because anyway kids are they say the kids are not even mature enough to go ahead and talk about their own privacy, right? Discipline matters more. And in the case of the government, we have seen how questions of surveillance has been raised against the government, especially recently with the whole news of Pegasus and government actually buying this Pegasus software from the Israeli company and using it to use surveillance on different categories of important and specific people, be it media personnel or people in the government, right? And then this system where data brokers are taking your data and making a profile out of it is already real. Google has been doing it, other different companies has been doing it. And the extreme of this that we spoke about, how there is a ranking system of individual based on this profiling, this is something that is already happening in China. China में they have a social credit system जिसके हिसाब से every single person is getting ranked based on how their social score is. उसी के चलते you can either be denied loans, you can be denied job opportunities, you can be denied benefits. And if you have a good score, you'll get better dating site matches, you'll get better rebates and better subsidies in your jobs and in your bills and policies and things like that. So all of this mandates that we speak about right to privacy. Now, from the question of UPSC has already asked questions on right to privacy. In fact, last year itself, they asked a direct question on right to privacy, right? And privacy as a topic has been in the news every single month, be it the procedural identification of criminal procedure identification bill, or be it the data protection bill, or obviously the Justice Puttaswamy case, which was the landmark case on right to privacy. So let's jump right into the class, and we're going to start the class by talking about the development of right to privacy. वो आया कहाँ से था? The constitutional debates that led to the right to privacy, and the different judicial precedents that were set leading up to the Puttaswamy Judgement. Right. So let's start the class. Now, right to privacy has always been regarded as a natural right. What is a natural right? A natural right is a right जिसको मानने के लिए कोई गवर्नमेंट और कोई गवर्नमेंट मैंडेटेड लेजिस्लेशन या जुडिशियल प्रेसिडेंट की जरूरत नहीं है. Natural rights are rights that are universal in nature, be it whatever culture there is, be it whatever government it is under. A good example of this is that the fact that we know that killing someone is bad. Killing someone is bad doesn't require a law or a legislation to be known by people that it's a bad thing to do. And on the contrary of that, punishing someone for killing someone is good. To punish someone for a bad deed is good. To do a bad deed is bad. This natural way of things decide what are natural rights. Similarly, my right to reproduce or recreate or procreate is going to be a natural right. It's a natural right by the sense कि हमको कोई rule or regulation नहीं चाहिए हमको बताने के लिए that we should reproduce. We don't need a rule regulation to tell us that we have freedom, that we have liberty. We don't need a rule to tell us that we should be earning for ourselves for our own survival. These are all natural rights. And in that same category itself, right to privacy is a natural right. Okay? And this natural right, if you look at different definition across different judicial pronouncements, you'll see the most common factor in the right to privacy would be this line that says the right to privacy means the right to be let alone. It means right to be let alone. Now, इसी का the definition that I've taken here is from Black's Law Dictionary, which says that right to privacy is right to be left alone or let alone, and it's also a right of a person to be free from unwarranted publicity. मेरी life के अंदर I don't want any sort of public interference or any sort of way in which the public is getting to know about me. And it says that it is also the right to live without unwarranted interference by the public in matters with which the public is not necessarily concerned. A very simple meaning of this कि मैं घर पे क्या कर रहा हूँ, क्या सुन रहा हूँ, क्या पढ़ रहा हूँ, has nothing to do with the public. So the public shouldn't be concerned with this. I can be listening to the Hanuman Chalisa, I could be listening to Lata Mangeshkar, the public has nothing to do with this. I have my own right in my own abode to listen to whatever I want to listen to or eat whatever I want to eat or do whatever I want to do, as long as I'm not obviously violating any law, right? So the right to privacy, mota mati, means the right to be let alone, that I shouldn't be interfered by public or individual in my own daily or personal life. And this belief has been there since the ancient times. जब से civilization came in and people started creating their own houses. लोगों ने अपनी dwelling जब से बनाना शुरू की, be it in caves, be it in tents, and be it in big large skyscrapers right now. The moment a person created his own house, he created his own abode, जिसके अंदर वो खुद रहता है, and this abode cannot be interfered or invaded by someone else without this person's consent. That itself gave birth to privacy. In fact, धर्मशास्त्र में हमारा जो हितोपदेश है, that says that every man shouldn't be compelled to disclose things about his family, worship, and sex. So it dates back like a long time. The concept of privacy comes from the concept of dwelling. जब से घर है तब से privacy है, because that was the need. Otherwise, everyone could have slept under the same roof, right? And it developed naturally from the ancient times. Hence, it's a natural right. For the first time, the right to privacy as a legal jurisprudence which was written did not come from a statute or a judgment. It came from a Harvard Law Review paper written by Louis Warren and Samuel Brandeis, who spoke about right to privacy back then in 1890. तब जो problem हो रही थी is something that we are facing right now also. Warren and Brandeis spoke about how newspapers papers, and instant photography or simultaneous photography has led to invasion of privacy in the life of public figures, be it celebrities, be it royal families. अब उस टाइम पे because cameras became instantaneous, people would start clicking photos of royal weddings or what is happening inside the house of a very big public figure, and that's where there would be scandals, there would be scams, there would be a lot of things happening. And in light of all of that, Warren and Brandis wrote this paper on right to privacy on how there has to be a line drawn between andar and bahar, between private and public, between a position where public should not interfere in private life. Now, to the counterpart of that, what was happening in colonial India back then, this happened in 1890, and in 1895, and by this time Congress is already here, Congress has already been formed, and there is like a increasing call for self-government. तो उस टाइम पे जो हमारा बिल आया था, कॉन्स्टिट्यूशन ऑफ इंडिया बिल 1895, which is also sometimes known as the Swaraj Bill, it for the first time spoke about the creation of a constituent assembly. Even though back then the idea was to be under the British Empire, but it spoke about having a constituent assembly for the very first time. So if in UPSC, if there is a question about how, when was the first time there was a mention of constituent assembly, it was the Constitution of India Bill 1895, or also known as the Swaraj Bill. Swaraj Bill of 1895. It is popularly believed that Bal Gangadhar Tilak was the main proponent behind this bill. Okay. Now, why we are talking about this bill from the context of right to privacy is because for the first time, this bill had 110 articles, and for the first time, this bill mentioned that a person's house is an inviolable asylum. इसका मतलब यह है कि एक person का घर is pavitra, it's sacred, it has its own sanctity, and it cannot be violated by another individual or state. So this was the first time it's said that there's sanctity in one's home or having an inviolable asylum. उसी का reiteration was the Commonwealth of India Bill, which again spoke about how there should be a right to property in the sense that people should not violate this property. There should be a right which talks about non-violation of a person's property, of an individual's property. And this later on again got reiterated finally in a much more strongly worded way in the Nehru report of 1928. Right? And then we move on to the first time when the debate on Constituent Assembly was actually happening, when M.N. Roy already proposed for a constitution and having a Constituent Assembly form this constitution. During that time, M.N. Roy also, with the help of the Radical Democratic Party, spoke about how a person should have the right of having an inviolable home, or a house that should not be violated. The sanctity of the house should not be violated by private or the state or public. So they again spoke about a private home or private property. And then finally, when we started having debates in the Constituent Assembly, we see that the Advisory Committee on Fundamental Rights, which was headed by Dr. B.R. Ambedkar, K.M. Munshi and Harman Singh, all three of them were big proponents of right to of having an inviolable asylum and the right to privacy as a whole. All three of them spoke about this. Harman Singh, who was influenced by the Czech constitution, said that yes, a person should have a private home. There should be a right to privacy in terms of home, in terms of the place where they're living, and it should not be violated. To this, K.M. Munshi added, for the first time, that right to privacy is not only the privacy of one's home, but it is also the right to have secrecy of correspondence. Now, secrecy of correspondence being mentioned for the first time here meant that the conversation that I have with someone else, मैं जो किसी से बातें कर रहा हूँ, that conversation shall not have any interference of an individual or a state. There should not be any surveillance on conversations. There shouldn't be any situation where the state is impeding in my conversation with someone else. So it is not, for the first time, right to privacy was elevated from just having the right to privacy be inside one's home and elevated to one's secrecy of conversations or correspondence. And to this, Dr. B.R. Ambedkar added and advocated that the right of people to be secure in their persons, houses, papers, and effects against unreasonable search and seize. So he made it even, he expanded it even more, and it also not only spoke about the person himself, it spoke about his house, papers, and effects that shouldn't be unreasonably breached by the state. Right? Now, while these Constitution Assembly debates were happening on the right to privacy, there were a lot of opposition to it as well. Because at that time, you see, India is becoming independent, and it is becoming independent in the face of a lot of communal tension. तब communal rights हो रहे थे, तब communal tension था, there was a big inflow of people happening between the India-Pakistan border. So, and on top of this, there was already a warlike situation that was happening with Kashmir, so with Pakistan. So, in this case, when so much miscreants are creating trouble for India, the opposition came from the side which said that right to privacy might be a big infringement in states' own right to regulate certain things. Usme the people who really read the charge against the right to privacy was B.N. Rao and Aladi Krishnaswamy Iyer. Now, B.N. Rao said that in a state where we are in right now, where there is so much tension, where there is so much communal conflict, in a state like this, giving right to privacy to an individual is going to impede in the state's power. It's going to impede in the state's authority and power to do police investigations or carry out any sort of investigation. And adding to this, A.K. Iyer said that it will be elevating a personal conversation to a personal or a public conversation to the level of state papers. जिसका मतलब यह है कि उन्होंने बोला कि ऐसे तो any person, any individual who's talking to anyone, the conversation they have, the secrecy in there is being elevated the same as the state papers that are being published on different information. जो confidential agreements, जो confidential documents जिसके बारे में बात हो रही है, how can we put a public or a private conversation to the level of that? Right? And this was echoed all throughout Constituent Assembly. It got a very big push from this side, and finally, and इसी के बीच में there were different other proponents who came up to advocate about right to privacy. There was Somnath Lahiri in the Constituent Assembly debates around on I think 30th April 1947, where he again advocated that right to privacy should be included as a separate right under fundamental rights. And then we had K.S. Karimuddin, who actually brought forward an amendment to the Part 3 of the Constitution Part 3 of the Constitution, fundamental rights, talking about installing right to privacy as a separate right. Now, all these debates that were happening became so heated, especially with the majority support being on B.N. Rao and A.K. Iyer's face, that Jawaharlal Nehru himself postponed these meetings, and later on, जब बाद में ये क्वेश्चन अमेंडमेंट दोबारा उठाया गया, उस टाइम भी इसके ऊपर कोई डिबेट नहीं की गई, जो अमेंडमेंट केस करीमुद्दीन लाए थे, विच वाज द लास्ट लाइन ऑन द राइट टू प्राइवेसी, उसके ऊपर कोई डिबेट नहीं की गई, एंड द अमेंडमेंट वाज डिफीटेड. इसकी वजह से व्हाट हैपेंस इज व्हेन द फाइनल ड्राफ्ट of the constitution comes out, the final draft that came out, the final draft had no mention of right to privacy. And this is a very important thing. The final draft of the constitution, when it came out and right after it became the constitution, there was no mention of right to privacy. And this had a very big impact on the judicial precedents that were being set when it came to right to privacy itself. So let's move on to the judicial precedents. Now, judicial precedent क्या होता है? When there is a landmark judgment, based on that landmark judgment, it sets a line, it sets a benchmark to the benchmark that will be followed further when other similar cases are being taken up, right? That's what the judicial precedent means. So the first landmark judgment in the case of right to privacy was the MP Sharma versus Satish Chandra in 1954. And now you'll see why the fact that the final draft did not have right to privacy mentioned in it matters so much. अब जो एमपी शर्मा वर्सेस सतीश चंद्रा का केस था, दिस वाज अ केस ऑन दालमिया ग्रुप. जो दालमिया ग्रुप था उसके अंदर कुछ फ्रॉड के एलिगेशंस थे, कुछ फोर्जरी के एलिगेशंस थे, दैट दे आर नॉट रियली शोइंग देयर ओरिजिनल बैलेंस शीट्स एंड दे आर फोर्जिंग द डॉक्यूमेंट्स एंड समहाउ गेटिंग अवे विद दिस. तो इसकी वजह से गवर्नमेंट पुट अ सर्च एंड सीज ऑर्डर ऑन 30-40 डिफरेंट आउटलेट्स ऑफ दालमिया ग्रुप. एंड ड्यूरिंग दिस सर्च एंड सीज, when the investigating officers were going through all their documents, they also started looking at personal documents. अब इस personal documents को देखने के चलते, the people from Dalmia group approached the Supreme Court and asked कि this is infringement of our Article 20 Clause 3 on self-incrimination. इनको तो ऐसे documents मिल जाएंगे या तो ऐसी बातें मिल जाएंगी जिसमें हमने शायद अपने आप को incriminate कर दिया. And they are also looking through private documents, which is an infringement on right to privacy. So this shouldn't be done. Now, in this case, what Supreme Court says, and this was an 8-judge bench. This was an 8-judge bench. The 8-judge constitutional bench says two things here. First, it says that agar constitutional makers, जिन्होंने who took a lot of inspiration from the American Constitution, and American Constitution के 4th Amendment में लिखा है, the 4th Amendment clearly talks about unregulated, unauthorized search and seize, and by that virtue it talks about right to privacy. The court said कि जब हमारे constitutional makers ने American Constitution में होते हुए भी right to privacy हमारे यहाँ mention नहीं किया, जब उन्होंने right to privacy यहाँ mention नहीं किया, तो हम कौन होते हैं to interpret right to privacy into something like this? It said it is the state has utmost power and authority when it comes to search and seize for public interest. तो उन्होंने दालमिया ग्रुप के लोगों का जो पेटिशन था अगेंस्ट राइट टू प्राइवेसी, इसको क्वॉश कर दिया और बोला कि अगर कॉन्स्टिट्यूशन मेकर्स ने ही कंसिडर नहीं किया राइट टू प्राइवेसी, देन हु आर वी टू टॉक अबाउट राइट टू प्राइवेसी एंड मेक इट इनटू अ लॉ. सो that becomes one of the major judgment that says that because right to privacy wasn't mentioned in the constitution, we are not going to talk about right to privacy, and the state has utmost rights for search and seize. ठीक है? Now उसके बाद we move to the next landmark case, which comes in 1962, which was the Kalaxing versus the state of Uttar Pradesh. Now in this case, in the Kalaxing versus state of Uttar Pradesh, so this was about the Dalmia group. This was about the Dalmia group, right? Now the Kalaxing case was a very interesting case. अब Kalaxing के ऊपर डकैती के चार्जेस लगे थे, ठीक है? उनको बोला कि this under the UP Police Regulation Act, they said that this person has been involved in dacoity, so this person needs to be produced in front of a magistrate. अब जब उन्होंने इनके ऊपर मुकदमा चलाया और सब कुछ किया, इनके पास enough evidence नहीं मिले, and they finally had to let Kalaxing go. But what the UP government did was, under the UP Police Regulation Act, उन्होंने Kalaxing के ऊपर surveillance put कर दिया. अब इस surveillance के अंदर बहुत सारी चीज़ें थी. There was a constant vigil on his house. Every person who was entering and getting out of his house was being monitored. There were also a provision of domiciliary visits. Domiciliary visits मतलब पुलिस किसी भी टाइम रात को या फिर कभी भी जाके उनके घर में विजिट कर सकती है चेक करने के लिए. एंड फाइनली ही हैड टू, एवरी टाइम ही इज समन्ड, एवरी टाइम Kalaxing is summoned, he had to come and report in a police station. So obviously this was a big infringement on his right, on his liberty and life and privacy. So Kalaxing goes to the Supreme Court. He mentions the same thing, that this is complete infringement of my own rights. And in this case, Supreme Court again says this, repeats a similar thing. Supreme Court says that, okay, while talking about your case, we can see how the domiciliary visit, कि रात को अगर पुलिस बार बार जा रही है आ रही है, तो you won't be able to live your life properly. So we are going to quash this down. We are going to quash the domiciliary visit part. ठीक है? where they said कि this is an infringement on your liberty, we understand this. But we are not going to stop the surveillance. Because back then court took the view that in your liberty, if someone's watching you, तुमको पकड़ के थोड़ी बैठे, तुम करो, तुमको जो काम करना है करो. The state is just watching you. We are not impeding on your physical rights. We are not impeding on your. We are not physically impeding. Physically stopping your movement. So we are not physically stopping your movement. We are not impeding on any of this. So why don't you go ahead and do whatever you want? I'm taking away the domiciliary visit part, but the state has the right to put surveillance on you. And they again reaffirmed the whole idea that if the constitution never spoke about right to privacy from this angle, who should we be? Why should we be the person who would need to like examine the right to privacy from that part? They only spoke about your right to life and liberty. But isme, there was one thing that became one of the major points of this judgment, which was the dissenting argument, the argument or the minority argument. So this was a 6-judge bench, and out of this there was Justice K. Subbarao, who said, and he was the dissenting or the minority judgment, who categorically mentions that any sort of state surveillance or interference in one's personal life is a impediment on their right to privacy. And they said that the right to privacy is a core of a person's liberty. उन्होंने बोला कि right to privacy is not just about physical impediment, but also the psychological effect you have on a person when you put them on surveillance. अगर आपको कंटिन्यूसली लोग देखे जा रहे हैं, अगर कंटिन्यूसली आपके ऊपर निगरानी रखी जा रही है, तो आप कितना मूवमेंट करोगे, आप कितना लोगों से मिलोगे या क्या करोगे? And that psychological impediment, that them stopping you from doing anything by your own volition, they are stopping your expression, they are stopping your, because Justice K. Subbarao said that this is not only infringement of movement, this is also infringement of Article 19(1), your own expression, right? So, and that when we come to later on talk about Justice Puttaswamy judgment and other judgments, we'll see that this minority judgment was what actually gave birth to the whole idea of right to privacy being an integral part of the right to liberty or Article 21, right? Then we move on to another landmark case, which was the Gohan versus the state of Madhya Pradesh. Now, this was a very similar case to the Kalaxing case. Again, on Mr. Govind, there was surveillance put by the by the Madhya Pradesh government. Surveillance put by the Madhya Pradesh government. Now, in this case, again, Govind goes and says that similar things, that this is an impeachment on my liberty, this is an impeachment on this is impingement on my right to life, right to movement, my freedom of movement is being curtailed. So this shouldn't be right. So in this case, the Supreme Court for the first time accepted the part that yes, this is an infringement. A person, if is being put under surveillance, is in fact an infringement on the right to privacy. But because this was a smaller judge bench case, they still had to follow the precedents being set by the larger benches, this 8-bench MP Sharma case and the 6-bench Kalaxing case. So इन्होंने बोला कि ठीक है, we agree that this is going to be an impingement on your right to privacy, but because we ourselves are not in a position where we can write the right to privacy into the constitution through jurisprudence. ये काम has to be done through legislation. So on one part they agreed that surveillance is a problematic thing when it comes to the right to privacy. It is something that hampers a person's right to life and liberty, but also they kept themselves from giving a judgment that writes a completely different article inside the constitution and said this should be done by the legislation itself. Then comes a very important case. The case which was R. Rajgopal versus the state of Tamil Nadu. अब ये जो केस था, this case was the case of Otto Shankar. Otto Shankar was a convicted serial killer who was later on to be given death sentence. अब ऑटो शंकर ने क्या किया? He started writing an autobiography inside the jail. While he was writing the autobiography, the court announced that he'll be given death sentence. So उसने अपना जो ये autobiography है, through his petitioners and through his family, he got it to a publication to be published. अब जो उस टाइम पे हमारे जो इंस्पेक्टर जनरल ऑफ प्रिजन थे, वहाँ पे उन्होंने बोला कि दिस शुड नॉट बी पब्लिश्ड बिकॉज दिस इज कंटेन्स इंफॉर्मेशन दैट इज डेफमेटरी टू द स्टेट मैकेनिज्म. बिकॉज अपेरेंटली ऑटो शंकर का कहना था कि आई हैव tie up with a lot of IS officers, IPS officers, and different people. And when I was committing these crimes, somehow these people were informed. And to this extent, the Inspector General of Prison said that this should not be published. He went ahead and threatened the publications not publish this. So the publication goes to the Supreme Court and says that this isn't right. This is an infringement on my right to freedom of speech and expression. So Supreme Court here takes one, and see, the case itself is a huge case when it comes to the right and freedom of speech, but there is a small tinge of right to privacy in this. It says two things. For the publication wala part, it says that agar Inspector General of Prison ko lag raha hai ki this is going to be defamatory, just by that feeling I cannot stop a publication. If you find this defamatory, then let the publication come out, because publication essentially is a right to express. So it says that if you find it defamatory post publication, you can go ahead and sue the publication, but you can't do it before it has been expressed, before it has come out. And in the case of right to privacy, it says that a person's private life cannot be put out in publication without their own consent. Agar you are about to write an autobiography about a person, you have been intimately involved with this person, you have been very close with this person, and you want to write an autobiography about this person without this person's consent, then this will be an infringement to that person's liberty and right to privacy. But to this, two exceptions lies. One, obviously, if this person's life and records that you are publishing already exist in public records, then you can publish about it, and that you have the consent of this person, and through this consent you are publishing these records. So for the first time, they spoke about informational right to privacy. They spoke about the informational privacy, or the part where information itself of a person could be private and cannot be published without the consent of that person. So Rajgopal versus State of Tamil Nadu spoke about informational privacy. Okay. Then we move to another landmark case, which was the Mr. X versus Hospital Z, 1998. Naam hi kitna interesting hai. You get curious about the name itself, because when this case came, it became a huge landmark judgment, because the question now was about a person's right to privacy versus another person's right to be informed. Case kya tha? Case mein a person was getting married. This person tested HIV positive. Right. Now, this person himself did not disclose, himself or herself did not disclose that they were HIV positive to the person they were getting married. The doctor who tested him took it upon himself and made this disclosure to the family. Or let's just say he made a public disclosure, right? So this person, and obviously the marriage was called off, and the marriage did not go forward. And to this effect, the person who was HIV positive approaches the court and says that it was my private information. The doctor has a right of keeping this confidential. There's a doctor-patient confidentiality agreement. There is something like this. This is a core of medical ethics, that a doctor cannot talk about my own medical condition without my consent. So in this case, isn't this my infringement on my privacy? To this, the Supreme Court says that this case is a little bigger than a person's own right to privacy. This is also about another person's well-being, another person's right to be informed. And for the first time, the state talks about that if I'm taking public interest into consideration, while weighing if a person's right to privacy versus a person's right to be informed is seen. Because see, there are under the criminal procedure code, that under the CPC, there is already a contention, there is already a section that talks about uh, affecting people with venereal diseases, right? So because there is already a section like that exists, because there is already the idea that you cannot voluntarily affect put someone into a disadvantageous position, because that goes against public interest. In this case, Supreme Court says that based on this idea, here the right to be informed weighs greater than this person's right to privacy, and rules that here what the doctor did it in a larger public interest. So this question was not just about your privacy, but this was about the larger public interest. So in this case, the Supreme Court held that yes, the right to be informed of this person in public interest was larger than the right to privacy of the other person. Okay, there were other things that was related to this judgment where the Supreme Court sort of went overboard with their own powers and put a ban on this person's ability to marry someone else, and told him that you cannot be married to someone else unless until you get cured from HIV, right? And this case later on goes and talks about the overreach of Supreme Court and something else. This is something that we'll talk in judicial review and judicial activism when we come to that. Now, finally, we come to this another landmark case, which is Selvi versus State of Karnataka case. This case, for the first time, spoke about mental privacy. Now, what is mental privacy? Now, इस केस में क्या हुआ था? The petitioner approached the court by saying that if someone is taking a polygraph test, a lie detector test, or a brain mapping test, in this case, isn't this an infringement on my own liberty? Am I not in liberty to answer certain questions and not answer certain questions? And by you getting inside my head, aren't you creating a situation where I don't even have a choice? So in this, the Supreme Court gave a landmark judgment by saying that a person's mind cannot be infringed by the state in any condition, which means that अच्छा, अगर investigation हो रहा है, अगर interrogation हो रहा है, if you are being interrogated by an authority, you have the right to not answer that question. You have the right to deny certain questions or be your own representative and answer it the way you want to answer it. But if you're put under an altered state of consciousness, if you're put under drugs, if you're put under brain mapping or polygraph test, that autonomy, that liberty to answer goes away. And that itself is an infringement on your fundamental right. On your fundamental right of Article 19, your fundamental right under Article 21, and this infringement cannot be allowed by the state. So for the first time, the Supreme Court has upheld the right to mental privacy. That brain mapping and a lie detector test and polygraph test cannot be done except with consent. If you have allowed the authorities to map your brain, or you've given them the consent to do a lie detector test on you, then and only then can that test can be said valid, right? And this doesn't have to be in the premises of court. The court says this doesn't apply to the premises of court. This applies everywhere or anywhere where a procedure like this might lead to your own incrimination. This article was very much involved with Article 23, which talks about self-incrimination. Again, this is something when we discuss constitutional, the fundamental rights under the Constitution as a broad aspect is something that's when we'll revisit the Selvi versus State of Karnataka. But from the aspect of privacy, right to privacy, the Selvi versus State of Karnataka is important from this part that it granted mental privacy. Now, a culmination of all these judgments and other smaller judgments led up to the Justice case Puttaswamy versus the Union of India case of 2017. Right, now this case was the biggest landmark judgment. This is for the first time that the Supreme Court accepted, and not only accepted, but wrote the right to privacy into the Article 21. It said, just because our constitution makers did not talk about it, doesn't mean that right to privacy isn't there or is not an intrinsic part of the constitution. They said, Supreme Court said that in this case, just because the Article 4 of the American Constitution talks about privacy, it doesn't mean that that is the be all and end all. And just because just because there is an absence of a comparable protection in the constitution did not apply that there was no inherent right to privacy in India at all. And while citing this, they said that right to privacy is not just about one person's own residence. It is also about this person's body, his choices, his mental privacy, his informational privacy, his sexual orientation, everything is a part of right to privacy, which is an intrinsic part of a person's liberty, life, and dignity. This is an intrinsic part. अब इस केस में, because the Justice case Puttaswamy versus the State of Union of India case was a case that also originated from the question of the Aadhaar, where in 2015 when people were petitioning against the fact that Aadhaar is collecting our biometric information and that biometric information is being used to access some state welfare programs, and just by not having a biometric authentication under Aadhaar might result in us being denied from these welfare programs. To this, when the Attorney General representing the Union of India, when he spoke about back then during the Aadhaar wala judgment, he said कि ये जो right to privacy है ये बड़ा ही elitist concept है. ये जो आज the लोग हैं who require the welfare programs of the state, they don't have any need for privacy like this. They need food, they need money, they need assistance. So it's good that right to privacy is being considered, but this is not something that needs to be considered for people who need such assistance. इसको quash करते हुए Supreme Court ने कहा right to privacy is a natural right. It's a right for every single person irrespective of their economic condition. It is a right of every single individual irrespective of whatever welfare is being needed by them. You cannot take it away from people just by saying that privacy can be forsaken for interest of welfare entitlements provided by the people, provided by the state. तुम नहीं ले सकते हो, right? They said that right to privacy is a natural right and the right to privacy cannot be infringed upon in any case other than, there also Supreme Court said that right to privacy is not an absolute right. They said कि ये जो right to privacy है इसको infringe किया जा सकता है if there are 3 conditions that are available. This was the test that the Supreme Court put forward, and the test was a threefold requirement of legality, need and proportionality. Legality में क्या आता है? Legality में it says that the state should create a legislation that postulates this infringement on right to privacy. कि अगर गवर्नमेंट ने एक लॉ बनाया है जिसके आधार पर ये राइट टू प्राइवेसी को इन्फ्रिंज किया जा सकता है या सुपर इम्पोज किया जा सकता है, तब हो सकता है. सेकेंड थिंग, द सुप्रीम कोर्ट सेज दैट देयर शुड बी अ नीड फॉर दिस. देयर शुड बी अ लेजिटिमेट स्टेट डिराइव्ड एम. देयर शुड बी अ प्रॉपर एम जिसकी वजह से ये राइट टू प्राइवेसी इन्फ्रिंज किया जा रहा है. इट कैन नॉट बी आर्बिट्री. स्टेट के पास एक पर्टिकुलर रीजन, डिफाइंड रीजन होना चाहिए जिसकी वजह से ये इन्फ्रिंज किया जा रहा है. एंड द लास्ट थिंग दे स्पोक अबाउट वाज प्रोपोर्शनैलिटी. जितना प्राइवेसी इन्वेट करने की ज़रूरत है उतना ही प्राइवेसी इन्वेट किया जाएगा, उससे ज़्यादा. दिस इज नॉट गोइंग टू बी एन ओवर आर्चिंग थिंग. It cannot be a thing where I've said now the right to privacy is going to be infringed, so everything is going to be infringed indefinitely. It has to be proportionate. It says that it should ensure a rational nexus between the objects and the means adopted to achieve them. There should be a rationale between how much privacy is going to be infringed and how it is going to be infringed and what is needed by the state. And you see, these were the threefold requirements for the restriction to be placed on right to privacy whenever it was to be placed on. And इसी को expand करते हुए Justice I think it was Justice S.K. Kaul, who said that there's a fourth unwritten requirement beyond these three, which says that ये जो interference होगा ना, that will happen, that should not be abuse of this interference. This interference on right to privacy should not be abused by the state, right? It should not be rampant. So the reason why this is a landmark judgment was because जो last हमारा landmark judgment था, which was given by the largest bench, was the MP Sharma case, which was an 8 judgment case, which already spoke about how constitution is not part of India because it was not spoken in the Constituent Assembly. But this, being a 9 judgment case, 9 judgment constitutional bench case, it overruled all the other judgments on right to privacy, and right to privacy became an integral part of our Article 21 of the Constitution. अब इसमें later on, Justice Chilameshwar went on to add that by giving right to privacy as a fundamental right, we are not only preventing the state from intruding, हम already state को रोक नहीं रहे just because हमने right to privacy बना रहा है, just because हमने right to privacy को fundamental right बनाया है, we are not saying that state is being now stopped. We are saying in fact that the state should do something to protect this right to privacy of every individual. It is not only about intrusion, but it is also about active protection granted to the people of India to be protected, for their right to privacy being protected by the state itself. And then later on, it was added that right to privacy is not just privacy of the body, it's also about sexual orientation. It is also about informational privacy, and leading from informational privacy, they spoke about a data protection law. For the first time, Supreme Court goes ahead and talks about the whole digital age of information that has come, and categorically mentions that the state should do something through a legislation or bring about a protection towards the data of every single citizen residing in the country of India. So this was the history of right to privacy. We saw that right to privacy has been there since ancient times. It was something that was spoken about before the colonial period. It was something that was spoken about during the colonial period, and then it was something that was also discussed about post-colonial period during our Constituent Assembly debates. हमने ये भी देखा कि Constituent Assembly debates में initially right to privacy की बात की गई थी, but वो final draft में आते आते it never made it to the final draft. वो final draft में आई ही नहीं. जब तक वो final draft में आया, the right to privacy was gone. And because the right to privacy wasn't written, all the judicial precedents that flowed from it ignored the part of right to privacy by mentioning the fact that ये तो constitutional makers ने डाला ही नहीं था हमारे constitution में, तो फिर हम क्यों करें consider right to privacy? And then slowly as the day and age evolved, the types of cases evolved, Supreme Court themselves evolved and created an idea that right to privacy of the person's mental privacy, a person's informational privacy is in fact part of liberty of a person. And ye karte karte we finally reached the Justice Puttaswamy case, which is the landmark case on right to privacy, which ends up writing that right to privacy is an integral part of our constitution. The next video we are going to talk about the Indian legislations that affect right to privacy. We are also going to look at the international laws that talk about right to privacy as a whole, and then finally conclude that class by talking about the 2-3 different bills that are coming, be it the data protection law, be it the DNA bill, or be it the criminal procedure identification bill of 2022. I hope you enjoyed the class, and I'll see you next time.